Banerjee বলছি না, I will do that when I introduce.
একেবারেই দরকার নেই।
আমি একটু তোমাকে পরিচয় করিয়ে দিই। আমি তুমি বলেই বলছি, স্যার কৌশিক আমার অনেক পুরনো বন্ধু, মানে হি ইজ বেসিক্যালি আওয়ার এক্সটেন্ডেড ফ্যামিলি, বাট হি ইজ ইন আ ভেরি গুড পজিশন ইন জাইডাস, আর তাই জন্য হি ইজ নাও টুডে আওয়ার স্পিকার। প্রিন্সিপাল ডক্টর শান্তিরঞ্জন পাল চৌধুরী, আমার কলেজ সম্মিলনী মহাবিদ্যালয়।
নমস্কার স্যার।
আচ্ছা, ডক্টর শিশির চ্যাটার্জি, IQAC কোঅর্ডিনেটর, রায়দিঘি কলেজ।
নমস্কার। নমস্কার কৌশিক বাবু।
হ্যাঁ,
নমস্কার।
ডক্টর শ্রীকান্ত মালাকার, IQAC কোঅর্ডিনেটর, আমাদের কলেজের সম্মিলনী।
নমস্কার।
আচ্ছা, অরুণিমা ইজ HOD মাইক্রোবায়োলজি ডিপার্টমেন্ট, রায়দিঘি কলেজ, ডক্টর অরুণিমা বিশ্বাস। আর এখানে ফ্যাকাল্টি আছেন কে? অরুণিমা, একটু শুভঙ্করকে পরিচয় করিয়ে দে কৌশিকের সাথে। ও সমস্ত ইয়েটা সামলাচ্ছে আমাদের।
ও পুরো টেকনিক্যাল সাপোর্টটা আমাদের ইংলিশ ডিপার্টমেন্টের হেড অধ্যাপক শুভঙ্কর ঘোষ রয় চৌধুরী, ও আমাদের IQAC মেম্বারও সামলাচ্ছে।
আর আমাদের কলেজের স্টুডেন্টসরা সবাই আছে, মোস্টলি আমাদেরই কলেজ, কিছু বাইরের স্টুডেন্টসরা আছে। তো আমরা ফর্মালি এবার শুরু করি নাকি অনুষ্ঠান?
হ্যাঁ 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 হ্যাঁ, এবার শুরু করে দিই।
খুব ভালো, বাইরের স্টুডেন্ট যদি আছে তো খুব ভালো।
হ্যাঁ স্যার, স্টুডেন্টরাও আছেন বাইরে।
হ্যাঁ, স্টুডেন্টরাও আছে, বাইরে স্টেট থেকেও স্টুডেন্টরা আছে স্যার।
বাহ।
হ্যাঁ, শর্মিলা দি, let us start.
Okay, now I formally start. Very good morning to all of you. On behalf of the organizing committee, I welcome everybody to this webinar on intellectual property rights, awareness, academics, and applications. Once again, I welcome our distinguished speaker, Dr. Kaushik Banerjee, without whom this would not have been possible. I welcome Dr. Shantiranjan Pal Chaudhuri, Principal, Sammilani Mahavidyalaya, Dr. Shishir Chatterjee, IQAC Coordinator, Raidighi College, Dr. Srikanto Malakar, IQAC Coordinator, Sammilani Mahavidyalaya, and all my students and faculties from other colleges and institutions. Now, this webinar is actually a joint venture of the two departments, microbiology departments of the two colleges, Raidighi and Sammilani. And we know that IPR, that intellectual property rights, is a very upcoming issue. And it has been included in the syllabus of microbiology because of its applications not only in the fields of consumers or health or pharma, but in applications of research and academics. So, with an objective of making the students aware of what is IPR, what is its implications and applications, and what is the necessity of studying IPR in your curriculum, we organized this seminar. And I'm very glad to say that we have a very distinguished speaker, Dr. Kaushik Banerjee, who has immense knowledge on IPR, and it is a very it's very fortunate for us to have him with us today. And I'm sure the students will gain knowledge by listening to his lecture. With these few words, I hand over the platform to Dr. Orunima Bishash, who will carry on the rest of the introduction and the program. Orunima.
Thank you, Shormila di. Am I audible?
Yes. Audible. Absolutely audible.
Good morning and warm greetings to you all. Thank you so much for being here today. I'm sure we are going to have a very enriching experience on IPR in the next couple of hours. But before that, may I first request Dr. Shantiranjan Pal Chaudhuri, respected Principal Sir, Sammilani Mahavidyalaya, to kindly say a few words. Sir, please.
Thank you. Good morning to everyone and welcome all of you. So today we are attending a seminar, very precious seminar, actually. So our intro about the senior we have been already introduced. So actually, the intellectual property rights. So that is very, very important, and we have a well-known speaker with us also in this web seminar. So, good morning, and again, I'm welcoming all of you. This seminar jointly organized by the Raidighi College and Sammilani Mahavidyalaya and the Department of Microbiology of both the colleges. I wish to extend my deep appreciation to Dr. Shashobindu Jana, Principal of Raidighi College, and to all of his colleagues, esteemed colleagues, and support hands to support this webinar. I express my sincere gratitude to the speaker, Dr. Kaushik Banerjee, General Manager of famous research institute, Zydus Research Center, Ahmedabad. শ্রদ্ধেয় কৌশিক বাবু কাছ থেকে আমরা বিস্তারিতভাবে সব শুনব এবং আমরা সমৃদ্ধ হব সাইড বাই সাইড। এই প্রশ্ন উত্তরের মধ্যে দিয়ে কিছু কিছু প্রশ্ন উত্তরের মধ্যে দিয়ে আমাদের এই সেমিনার এগিয়ে যাবে, এইটুকু আমরা আশা করি। I am sure we all of you have a fruitful exchange of ideas today. I hope we will have an engaging and enriching session ahead. I express my thanks, sincere thanks, especially to the conveners of the two colleges. And I am sure that we will feel prosperous by the knowledge we received after the webinar. I welcome all of you once again. Thank you.
Thank you, sir. Thank you so much for your encouraging words. Dr. Shashobindu Jana, Principal Raidighi College, could not be present today due to unavoidable circumstances, but he sends his best wishes and he wishes this webinar all success. So thank you, sir. May I now request Dr. Srikanta Malakar, IQAC Coordinator, Sammilani Mahavidyalaya, to kindly address the audience.
Okay. Am I audible?
Yes.
Okay. Respected principals, Dr. Shashobindu Jana, Raidighi College, and Dr. Shantiranjan Pal Chaudhary, Sammilani Mahavidyalaya, Speaker of the Day, Dr. Banerjee, General Manager, Zydus Research Center, Ahmedabad, IQAC Coordinator of Raidighi College, Dr. Shishir Chatterjee, conveners of this webinar, Dr. Orunima Bishwas, Raidighi College, and Dr. Shormila Chakraborty, Sammilani Mahavidyalaya. Dear colleagues, my friends and participants, very good morning and greetings to you all. It's my great privilege to grace you all in the national level webinar on intellectual property rights, awareness, academics, and applications jointly organized by the Department of Microbiology and IQAC of Raidighi College and the Department of Microbiology and IQAC of Sammilani Mahavidyalaya. As we know that the 21st century belongs to the knowledge era, and mainly it is driven by the knowledge economy. There is an economy that creates, disseminates, and uses the knowledge to enhance its growth and development, and thus there is a need to propagate the value of transforming knowledge into intellectual property assets, that is IP assets. We know IP, that is intellectual property, refers to the creations of the mind, such as inventions, literary and artistic works, designs, and symbols, names, and images used in commerce. Intellectual property is protected in law, and it enables the people to earn recognition or financial benefits from what they create or invent. That is, the law gives the creator an exclusive right over the use of his or her creation for a certain period of time. So, the knowledge of intellectual property rights and its application is of extreme importance in today's world, and thus the topic of this webinar is very relevant. And I am sure that the webinar will be beneficial and productive for everyone present here. I would like to express my heartfelt gratitude to all of you who are sincerely committed to this webinar to make it a great success. And I wish every success of this webinar. Thank you all.
Thank you, sir. May I now request Dr. Shishi Chatterjee, IQAC coordinator of Raidighi College, to address the audience.
Respected Principal Sir, Sammilani Mahavidyalaya, conveners of today's webinar, organizing committee, our teachers and students, and obviously our main speaker, Kaushik Babu. First of all, I congratulate on behalf of Raidighi College IQAC and Principal Sir for today's webinar. For unavoidable circumstances, he is not present here, but he conveys his best wishes to me for today's webinar. Secondly, I also congratulate all the brothers and sisters of Sammilani Mahavidyalaya because they are going to celebrate their silver jubilee in coming December. From inception, they are our sister concern. We are very much grateful to the Sammilani Mahavidyalaya since 1995 of our establishment. Secondly, this is the program IPR, based on IPR. The term is very heavyweight. We all know so much about GI tag, Rasgulla, Haldi, Basmati, trademark, Bollywood piracy, everything. But for the people of Sundarban, biopiracy is a very important issue. We need to protect our traditional knowledge. We need to protect our food grains, seeds. We need to protect medicinal plants. So, in this case, we need to concern about IPR properly and address this issue on application field and on as well as academic field. Lastly, if you excuse me, I just want to share a few words in Bengali with our local students. আমাদের ছাত্রছাত্রীরা যারা কৃষি পরিবার থেকে সুন্দরবনের আছে, সম্মিলনী কলেজেরও প্রচুর ছাত্রছাত্রী আছে যারা কৃষক পরিবার থেকে এসছে। এখানে একজন বিশিষ্ট মানুষ বক্তব্য রাখবেন। রাইডিগি কলেজের আইকিউএসি সোশ্যাল রেলিভেন্ট বা মানুষের কাজে লাগে এমন বিষয়ে অংশগ্রহণ করে। আমরা চাই তোমরা প্রত্যেকে এমনভাবে এই বিষয়ের আলোচনা শোনো যাতে সুন্দরবনের আগামী দিনের ভবিষ্যৎ তোমাদের নিজেদের সম্পদ, জ্ঞান এবং ভাবনাকে সংরক্ষিত রাখতে, সুরক্ষিত রাখতে এবং আরো এগিয়ে নিয়ে যেতে সেটা তোমাদের কাজে লাগে। সকলকে ধন্যবাদ। মেনি থ্যাঙ্কস টু অল অফ ইউ।
Thank you, Dr. Chatterjee. So we will now move on to our main program. The participants are requested to kindly keep their audio and video in off mode and to type their questions for the speaker in the chat box. We will discuss them during the interactive session. Please do not click on the present now button during the lecture, and when the speaker presents his slides, kindly pin to the presentation screen for uninterrupted viewing. So please remember that the feedback link will be posted in the chat box towards the end of the valedictory session. And so may I now request Dr. Shomila Chakraborty, convener, Associate Professor and Head Department of Microbiology, Sammilani Mahavidyalaya, to introduce today's speaker, Dr. Kaushik Banerjee.
Thank you, Arunima. Am I audible?
Yes, yes, you're audible.
It is my privilege and great pleasure to introduce Dr. Banerjee to all of you. He is the General Manager of Zydus Research Center under Cadila Healthcare Limited, which is a leading Indian pharmaceutical company. Dr. Banerjee did his master's in chemistry from the University of Calcutta. Then he did his PhD and from University of Baroda, and he has also a law degree, LLB, LLM degrees from the University of Gujarat. He has also an associateship in information sciences and a PG diploma in intellectual property law. Professionally, Dr. Banerjee is a registered patent agent of Government of India. He joined the program of Japanese Patent Office JPO in 2006 in Tokyo with a full scholarship and qualified in their program JPO IPR course for patent experts. He also has a degree of Management Development Program from Indian Institute of Management, Ahmedabad. Dr. Banerjee has 8 publications and 8 patents to his credit. He is the leading IP initiator at Zydus Research Center. He leads a managing team of IP professionals and is collectively responsible for all IP matters at the R&D Center, Biotechnology Division, Vaccine Technology Center, and their progress into the Indian market. He has immense contribution in bringing several products of Zydus Cadila healthcare system to the market through developing non-infringing and patentable product development strategies. The important medicines to which he has contributed and the patenting policies of his company are Lipaglyn, clopidogrel, etoricoxib, PEG-IFN2B, adalimumab, and trastuzumab. So it is very essential, it seems, from his biodata that how IP professionals have a great role in bringing the pharmaceutical products to the market for our benefit. Dr. Banerjee is also a visiting faculty to several postgraduate uh, institutes under University of Gujarat for the last 15 years. He has delivered lectures on IP-related matters organized by CII, IPA, ICC, FICCI, and various academic institutions on various topics of IP. We are very glad that Dr. Banerjee could give time out of his busy schedule for this webinar, and I would not prolong this anymore. Over to Dr. Banerjee.
Thank you. Thank you very much for those introductions and uh, all the discussions that we had by now. Uh, I was just thinking as I was hearing the speak, some of you speaking, was that I hope I'm audible.
Yes, you are audible. You are
Okay.
audible.
About the plant rights and other things. So honestly, my presentation may not cover those aspects in details because that's something which I did not fathom that would come up. But what I would like to put in initially is that the concepts what I'll be talking about applies equally when we are talking about either biopiracies, whether we are talking about protecting your traditional knowledge and things like, because that itself is a completely, I mean, it's a full topic and subject in itself. How do you protect your natural resources? How do you protect your traditional knowledge and things like that? And that's becoming extremely important. I'll touch upon that. In a small way, but it's something which is important, and whatever we would be talking today has relevance in some way when you think about protecting your in India's traditional knowledge, India's biodiversity and things like that. So probably at the end, if there is the time permits, we can discuss a little bit on that. Though it may not be part of the presentation as such. So I think thank you everybody for inviting me, and it's something which I feel amazed even now after 1 year of talking talking to my computer on different things, and not only during presentations, during meetings, but also hearing, attending courts and other things. That, think of it, I mean, this is what innovation is about. This is about how men at work creating new solutions to problems that we are facing. The COVID-19 has pushed us to find out new solutions, and the world and the people of the world has actually come up with solutions which could not even think of after before 2 years. Think of it. 2 years before, if somebody told that you want to have a vaccine in a year, we want to make a vaccine in a year, anybody who said that, most people would have said you have a special place in an asylum. But now, because of what people can do, what men with intellectual developments and the intellect using human intellect, what we have is, in a year, not one, we have 4 or 5 different vaccines. We are doing 1 crore vaccinations a day. I mean, there can not be anything more a proof of what human intellect can do if faced with a situation where you need to find solutions. And that's about innovation. That's about what intellectual property or intellectual development by human being is. So innovation is something which is very, very close to me. And today I'll be talking a little bit about innovation. I'll be talking a little bit about how do you protect innovation. And also I will be talking about, since ultimately I come from the business, I'll be talking about some of the things which needs to be taken care when you are developing a product, whether it is an innovative product or whether you're making something of a copy. What certain things which you need to keep in mind when you are developing a product or a process or something which has a commercial benefit. And also I'll be talking about a little bit about the strategy about whether you want to publish, whether you want to patent, and what are the questions to be asked if you want to take a particular decision with respect to the intellectual property that you have generated. I'll be talking about that, and probably at the end I'll quickly touch about 1 or 2 examples of how intellectual property, managing properly your intellectual assets, creates value for the organization. That's what I intend to cover today. Now, so with that, I'll start the presentation. Just let me know once it is visible.
Not yet visible. Let's see.
I think I'm a little bit on this. So give me a second. Oops.
That's perfectly okay. Take your time.
I got it. Is it visible now?
Yes. Can you make it full screen?
Yes, that I can do. Better? Is it better now?
No, ফুল স্ক্রিন হয়নি এখনো, দেখো তো।
আমি তো এখানে ফুল স্ক্রিন দেখাচ্ছে।
স্যার আমার
Sli-
if you excuse me, আমার মনে হয় আপনি যদি আবার স্টপ শেয়ারিং করে আপনি যখন রিশেয়ার করছেন বা রিপ্রেজেন্ট করছেন তখন দেখবেন একটা আসে শেয়ার ইওর হোল স্ক্রিন বা এরকম কোনো অপশন আসে। আপনি পার্টিকুলারলি হয়তো এই মুহূর্তে এই ডকুমেন্টটাকে প্রেজেন্ট করেছেন, সেই জন্য আপনি ফুল স্ক্রিন করলেও ওটা শুধু ডকুমেন্টকেই দেখাচ্ছে। আপনি হোল স্ক্রিন শেয়ার করুন, তারপর ঠিক দেখাবে।
ওকে, ঠিক
ওটা একবার হ্যাঁ বেরিয়ে গিয়ে হোল স্ক্রিন শেয়ার করতে হবে।
ওকে, দেখছি। নাহলে ছেলেকে ডাকতে হবে। লাস্ট অপশন।
ঠিক আছে, টেক ইওর টাইম, খুব দেরি হয়নি এখনো কোনো কিছু।
শেয়ার
শেয়ার হোল স্ক্রিন আর কি।
শেয়ার still it's not coming up. না, এইভাবে হবে না, ওই স্ক্রিনটাকেই করতে হবে। এখন বেটার?
কিন্তু হোল স্ক্রিন হচ্ছে না তো।
কৌশিক বাবু, আমার যেটা মনে হয় আপনি যেখানে আপনার পাওয়ার পয়েন্ট পিপিটি বা যেটা সেখানে ক্লিক করুন, এখানে না করে ওখানে খুলে যাবে।
এবারে
মানে এখানে না ক্লিক করে আপনি এটাকে মিনিমাইজ করে আপনার যেখানে আমরা প্রেজেন্টেশনটা আছে সেটাকে ক্লিক করুন, দেখুন সম্ভবত হোল স্ক্রিন মানে টোটাল স্ক্রিনে আসবে।
এবারে সেটাই করলাম তো, শেয়ার দিস
স্লাইড শো মোডটা ক্লিক করুন না স্যার।
স্লাইড শো মোড, হ্যাঁ তাই করেছি।
আচ্ছা F5 প্রেস করে দেখুন তো আসছে কিনা।
F5 ও করলাম সব না, আমার কাছে এটা ফুল স্ক্রিন দেখাচ্ছে।
ও আচ্ছা,
আমার কাছে ফুল স্ক্রিন দেখাচ্ছে, এটাতে আরেকটা অপশন।
আমাদের এখানে এরকম হচ্ছে না, তাহলে
একটু বুড়াইকে ডাকো না।
স্লাইড শোতে যাও।
স্লাইড শোতে
ফ্রম বিগনিং করো।
আমার কাছে তো এটা ফুল স্ক্রিন দেখাচ্ছে।
আচ্ছা, আমাদের কি সবাই কি ফুল স্ক্রিন দেখতে পাচ্ছে? পার্টিসিপেন্টসরা
সৌম্যদি, আমি ফুল স্ক্রিন সেল ফোনে দেখা যাচ্ছে কিন্তু কম্পিউটারে কিন্তু আসছে না। সেল ফোনে কিন্তু আমি ফুল স্ক্রিন দেখছি।
ঠিক আছে, কোনো অসুবিধা নেই। যদি সেল ফোনে দেখা যায়, ছেলেরা তো ফোন থেকেই দেখছে, তাহলে ইউ ক্যান প্রসিড।
মানে আমি বুঝতে পারছি, জানি না
আমি
শর্মিলাদি, তুমি একটু লেআউটটা চেঞ্জ করো। দেখো ওই যেখানে ওই প্রেজেন্টেশনের অ্যারোটার পাশে তিনটে ডট দেওয়া আছে না, ওটাই ক্লিক করলে চেঞ্জ লেআউট আসবে। ওটাই গিয়ে স্পটলাইট করে নাও, করলে একটু বড় হবে।
হ্যাঁ ঠিক আছে, ছেলেরা দেখতে পেলেই হলো। আমি ঠিক আছে, আমার অসুবিধা হচ্ছে না। ঠিক আছে, ইউ ক্যান স্টার্ট তাহলে।
ওকে, সরি, technology has its benefits and also its challenges, especially for people like us who are not so comfortable with technology. আমি এখনো পুরোনো ফরম্যাটে ফোন and EFL prefer করি, but these are things which we have to adapt. It was this is something which to me is phenomenal. That sitting in Ahmedabad, I'm speaking to people in Calcutta, Kolkata, and so many people listening to me simultaneously. For us, presentation used to mean going to a place, giving a lecture and things like that. Now I'm only talking to the screen. Anyway, so what I was talking about is the value of innovation, and what uh, creative people can do, and faced with a problem, our collective ability to solve, to try and solve a problem gives us such results which we could not even think, which are kind of science fiction, could have been science fiction a couple of years earlier. Now we are living them. We are living them every day. So since as I said, I come from the industry, so probably I'll start with uh, about trying to, when you try to develop a product, when you're making a product, the product can be either an innovative product. You can be developing an innovative product, or you could be developing a copy of an existing product. So what we call as a generic product. So you, any product that you are developing would ultimately fall into any of these categories. So and when I say product, you have to look at it in a broader sense. You could also, I mean, when I say you could create a new music, or you could be either you could be improving of an existing music, or you could be just copying an existing music. Rabindra Sangeet has been sung by so many people. The original copy was prepared by Gurudev, and we have generations of artists who have been singing the same song, and somewhere down the line putting in their creative endeavors also. So therefore, it's not, when I'm saying product, when I'm saying product, it has to be thought about in a little bit an expansive way. It's not about only specifically product as we mean it. It's anything which is a creative output of human endeavor. So that can be something which is new, or it can be something which already existed and you are trying to make a copy of it, or you are also could be also trying to do something different with it, to put your interpretation, to improve upon it, or doing something further on it. So if you look at it from those perspectives, so most all products would be falling under any of these two categories. One is the innovative products, and another is the generic equivalent of an existing product. So for innovative products, these are some of the characteristics. It is a new to the world. It is you first time you have created something. It involves innovation. And why are you doing it? You want to provide a new or a better product to the society. A new product normally caters to an unmet need. The new vaccines that we have got for COVID-19 satisfies the huge unmet need for treating patients with COVID. So therefore, a new product generally caters to an unmet need. Sometimes it solves some of the problems of the existing products. So what you have is a better product, a product which solves or improves upon some of the issues with an existing product, and those we see every day. It creates new market. Now think of it that this mRNA technology, which have been used to create this first generation of vaccines, has created a huge new market for medicines using this mRNA technology. Not only for vaccines, people are now using mRNA technologies for creating products, for creating medicines for so many new diseases. So it opens up new market, new possibilities, new way of doing things. It adds new knowledge. Whenever you create something new, it adds to the total year of knowledge that we have, because you have created something which did not exist earlier. So therefore, you're creating something. The moment you create something new, you add some new knowledge to the existing knowledge base. And obviously, the whole purpose of innovation is to contribute to the society's development. Society develops because people innovate. Societies develop because people have the hunger to provide new solutions to existing problems. So therefore, innovative products plays a big role in developing society. So these are some of the characteristics of innovative products. And when we talk about generic equivalence, these are some of the characteristics of a generic product, a copy of an existing product. There is less innovation because you are copying something which already existed. One of the primary reasons why you make a copy is that you try to reduce the cost. Innovation costs money. We'll talk about it. Innovation costs a lot of money. So the innovative products are costly. We know that.
Excuse me, sir.
Yeah.
আমি অর্ণিমা বলছি কৌশিক দা, আপনি কি স্লাইড চেঞ্জ করছেন? মানে আমরা এখনো প্রথম স্লাইডটা
হ্যাঁ, প্রথম স্লাইডে আছে, আমি প্রথম স্লাইডে।
আচ্ছা, ঠিক আছে।
So one major reason why you make a copy of an existing new product is that it helps reduce cost. That's one of the primary drivers, and therefore it increases access. Think of it, when the first mobile phones were introduced, it cost people a go. Even the network charges, the calling charges, it used to be almost like 10 rupees, 30 rupees per second, 40 rupees per second. So, because that was first time mobiles introduced in India, that was at that time an innovative product back in 1999-2000. In US, it was introduced earlier, but in India, it was introduced something like 1999. So the cost of the mobile and everything was prohibitively expensive, and most people could not even think of having a mobile phone. Today, everybody has a mobile phone. And why did it happen? Because so many companies today are making mobile phones and they are investing in reducing cost. So therefore, it increases affordability, increases accessibility. So these are two primary reasons why people make a copy of an existing product, because that increases access to people. And also by doing that, you improve efficiency, do a lot of process innovations, which helps in developing the next set of innovation products, because you you get a lot of knowledge by when you do a process optimization, things like that, and that again goes back to developing the new set of innovative products. So therefore, innovations do happen there, but not in a scale when you are developing a new to the world product. So these are basic characteristics between the two classes of products which people normally make: innovative products and products which are copy of an existing product. So in the first class of products, protecting this innovation becomes very critical. And when you are making a generic equivalent, you have to ensure that you don't trespass somebody else's property rights. We'll talk about it as we go through, but these are two basic differences in mindset when you're talking about innovative products and generic equivalent. Innovative products, the primary aim is, if you are making an innovative product, IP will help you to protect that innovation. And when you are making a generic equivalent, your knowledge of IP will help you ensure that you don't trespass somebody else's property and therefore end up in a very costly and time-consuming legal process. So these are two facets in which your IP knowledge will be helpful when you go to the industry, go outside the world and try to make new, when you are in the process of developing something new or trying to develop something which is an existing copy of an existing product. So these are kind of the basic difference between these two products and how IP plays its role in these two areas. So innovations, we know it's a new idea and new idea brought to practice. So these are some of the definitions. Innovation is a process by which varying degrees of measurable value enhancement is planned and achieved in any commercial activity. So innovation means
স্লাইড চেঞ্জ করছো কি?
স্লাইড চেঞ্জ করলাম তো
না, দেখছি না আমরা স্লাইড চেঞ্জ।
এই তো দেখা যাচ্ছে,
সবাই কি দেখতে পাচ্ছে? আমি কিন্তু দেখতে পাচ্ছি না স্লাইড চেঞ্জ।
না দেখা যাচ্ছে না।
না, দেখা যাচ্ছে না।
আবার তাহলে ট্রাই করতে হবে।
হ্যাঁ, এবার একটা স্লাইড দেখা যাচ্ছে ইনোভেশন।
ইনোভেশন দেখা যাচ্ছে?
হ্যাঁ, দেখা যাচ্ছে, দেখা যাচ্ছে।
So this is the definition of innovation. I mean, there are hundreds of definitions, but basically, when we are talking of innovation, we are trying to what we are trying to say. You are bringing in something new which did not exist, and it could be something very small, incremental, or it could be disruptive. So it could be anything. But when you are trying to bring something new in over whatever today exists, then we are talking of innovation. And it starts with an idea and ends with a product. So that's the whole life cycle of innovation. You start with an idea, you practice it, you test it, you improve upon it, get a product, and then the next cycle of innovation starts. So as Peter Drucker said, it is about change. So innovation brings in change, and bringing in change is something which is the only constant we know in society. So therefore, innovation drives that change in the way we exist today, we do things, and brings us to better product solutions and better way of doing things. I've changed the slide.
No, slide is not changed. Slide is not visible.
Takes time maybe. See.
ইনোভেশনের স্লাইডটাই দেখাচ্ছে,
এবারে
পরের স্লাইডটা যায়নি। সবাই কি দেখতে পাচ্ছে পরের স্লাইডটা? আমি তো, আমার হয়তো এখানে অসুবিধা হচ্ছে।
The slide title is innovations.
হ্যাঁ, that is there.
Industrial innovation.
No. অরুণিমা?
না, আগে স্লাইডটাই আছে।
হ্যাঁ, ন্যাশনাল ল কমিশন, গভর্নমেন্ট অফ ইন্ডিয়া, যেটা তুমি বললে এক্ষুনি। হ্যাঁ,
তাহলে এক কাজ করি, let me share this slide on email.
তাই করবে কি?
হ্যাঁ হ্যাঁ, সেটাই সুবিধা হবে।
আমি মেল করে দিচ্ছি,
আচ্ছা,
and probably somebody can do it from there, and I can.
হ্যাঁ, আপনি নেক্সট স্লাইড বলে যাবেন, আমরা
otherwise এ তো শেষ হবে না।
হ্যাঁ হ্যাঁ, ঠিক আছে, ঠিক আছে।
তাহলে শর্মিলা, আমি পাঠিয়ে দিচ্ছি তোমাকে।
ঠিক আছে
শর্মিলা, হ্যাঁ, তুমি আমাকে মেল করে দাও, আমি হয় চেষ্টা করছি নিজে, নাহলে শুভঙ্করকে শেয়ার করে দিচ্ছি।
ঠিক আছে, ঠিক আছে। টেকনিক্যাল প্রবলেমও হতে পারে।
হ্যাঁ, হতে পারে, মানে ব্যান্ডউইথের ইস্যু হতে পারে।
পাঠিয়ে দাও, it will just take a minute, no issues.
জিমেলে পাঠাচ্ছি।
হ্যাঁ হ্যাঁ হ্যাঁ, ঠিক আছে।
ততক্ষণে আমি এক কাজ করি, ওই স্লাইডটাকে আবার শেয়ার করি। তাহলে একটা স্লাইড করে শেয়ার করতে যাচ্ছি যতক্ষণ না।
হ্যাঁ হ্যাঁ হ্যাঁ, ঠিক আছে, তুমি কন্টিনিউ করো না, কোনো অসুবিধা নেই।
So is the screen now visible? Industrial innovation. Okay, so let's do it this way. Till the time you can fix it. Okay, so innovation can be anything. So broadly, it can be divided into two ways. One is industrial innovation, and the industrial innovation includes any new products, processes, operations. So it has to do with industrially useful products, processes, which can be used in the industry. So that's the first class of innovation. Broadly, you can, if I divide it, and it could be new products, processes, operations, marketing and sales techniques, manpower management, prioritizing, allocation. So it's not only about products and processes, it's also about how do you manage your people, how do you allocate your resources. You know, we know Amazon today is what Amazon is, not because, yes, the codes and other things are important, but it's also the way they manage their logistics, the way they manage their sourcing, the way they manage their uh, deliveries. All of them taken together makes Amazon such a formidable entity. So all of these are innovations which are are something which may not be part of a product, may not be part of a process, but the way they do things are all part can are innovations which allow makes Amazon what Amazon is today. So when we're talking of industrial innovation, it is not only about products or processes. It entails anything and everything which makes your cost of doing business lower, which brings down the cost of your business, which provides you some advantage over all your rivals. So that's industrial innovation. And the other innovation part is aesthetic innovations, which includes all our creative endeavors in the fields of novels, drawings, poetry, recitations, dance performance, which are more of a creative kind. This has less in the industry, but it helps us in other ways. It helps people be relaxed, it helps people enjoy things. Those are innovations in the creative space, and that's another class of innovation, which is aesthetic innovation. So let me again stop and go to the next slide. Triggers for
Again,
innovation.
yes, it's visible. Huh?
So, so what could be? I mean, these are some of the. Why do we innovate? We innovate for n number of reasons. It could be solving an existing problem, creating, finding that there is a gap in the market. You try to fill that gap. There are performance failures. You want to improve upon that. Cost and efficiency service. So therefore, there are n number of reasons why you innovate based on and the reason for your innovation probably drives you to the solutions that you provide. So I first step if you are trying to venture into the journey of innovation is to try to find out what is lacking. It could be a new market, it could be a new product, but something you have to identify that this is lacking. This is something which the society does not have, or this is where the society is or people are not getting the solutions that you think is optimal. And then you start your journey in trying to solve those problems, to create that new things, to get something which probably gives you the next $1 billion idea. So these are some of the triggers of innovation. Crisis. COVID was a crisis, and see how the world has responded, not only in terms of medicines, but in terms of the solutions that we are today using. World has come up with so many new solutions which could not have been thought maybe 3 years back. So crisis is a major reason why people innovate. You get some new insights and ideas, you want to test it, and by the end of the day you get a new product or a process. So those it could be anything which triggers your interest to create something new. So that's some of the triggers of innovation. By any chance you're seeing the next slide?
হ্যাঁ দেখা যাচ্ছে innovating is not easy.
Great. So I think it's working. So innovation is not easy. You know why? You know, the first thing is you are venturing into the territory of unknown. You don't know what you are trying to do. You have an expectation, but you don't know what it is, whether you'll be solid, whether it will work or not. So fear of the unknown. So most of us don't venture out because we fear that I'll fail. High risk of failure. Ideas are meant to fail. I mean, 99% of the ideas fail. If you do a more better mathematics, it could be 99 point something. So most ideas will fail. So why risk it? It's a very competitive field. Everybody is trying to chasing the next $1 billion ideas. So think of it. We wanted a vaccine, COVID vaccine. In 1 year, we have at least 45 different vaccines in the clinic. Everybody, so many, I mean, it's unthinkable that 45 different vaccines in the clinic in a year. So that's the level of competition. Yes, it benefits society, but for an individual who is going into trying this, think of the competition that person is going to face. So therefore, there's a huge competition. It is expensive. Drug discovery is not only drug discovery, any innovation process is a very expensive process. Drug discovery requires millions of dollars. We know that. I mean, with such high layer of failures, it's a huge investment, very costly. It's a cost. It's not cheap. You have to understand the future consumer demand, because what you are creating is not a solution for today. If you're trying to create a solution for today, by the time you create the solution, the world has moved away. So you have to think about what consumers will need 2 years, 3 years, 4 years down the line when you're trying to solve a problem or create something new today. You're not, because it will take time for you to create the product. It will not happen in a day. It will take years to make the product. So by the time, and there are examples after examples where by the time the product, which was thought of to be a great product the day when it was thought, by the time it reached the market has moved on. You need to acquire new skills and capabilities, because your existing skill may not always be suitable to create something new. So today, if somebody has to prepare a vaccine, he has to learn about mRNA technologies. We all are learning new technologies, new way of doing things. Even the siRNA and other things which are coming up today. So if you have to play in that field, you have to learn those technologies. You may not have all the skills and capabilities to get into that field. Or if you'll be doing something which is 10 years old, there is no market for that. So if you have to do something new which has a market, you have to really build your capabilities, skills to the extent that you are able to compete in that field. Create something which is, because you will be creating something new. It's not something which existed. So, and it has to be always in the cutting edge of technology. So you have to learn those skills in order to be able to play in that field. Long gestation period. Some of the fields takes a lot of bringing a drug to the market takes at least 8 to 10 years. Forget about the COVID situation. This is unique. Otherwise, normally it takes 8 to 10 years for bringing any product to the market, drugs to the market. Future market disruptions may kill today's brilliant idea. Today, you have a brilliant idea, but by the time you bring it to the market may have been disrupted by something else. This is a classic example. Bill Gates predicted that his tablet would be the most popular form of PC sold in America within 5 years. When he brought the first tablet was brought by Gates, Microsoft. And he said in 5 years, this will be the product everybody will be using. And then Apple came in. And we know what happened to today. Nobody uses tablet of Microsoft. So Apple completely disrupted the market, which Bill Gates predicted for his product. So that kind of disruptions will completely kill your innovations by the time you have your product in the market. And it requires long-term commitment of the management, because it will take time, it will require a lot of investments. You will fail. You'll fail hundreds of times before you get an idea which clicks. So therefore, it requires a long-term commitment from the management, and it's not easy. coming from the industry, I can tell you it's not easy to convince management that please go on funding us. It's extremely difficult. So these are some of the challenges which you face if you get down to the innovative path of innovation. I was the next slide.
কৌশিক দা আমি প্রেজেন্ট করব, আমরা পেয়েছি মেইলটা।
ঠিক আছে আমি বন্ধ করছি।
হ্যাঁ,
we start at why protect innovation.
ওকে। স্ক্রিনটা কি এসছে?
হ্যাঁ এসছে, আমি তো দেখতে পাচ্ছি। রাইট, এখান থেকে স্টার্ট।
এক মিনিট, আমি একটু নিজেকে মিউট করে নিই, এক সেকেন্ড। শর্মিলাদি সবাই দেখতে পাচ্ছ তো? আমি প্রেজেন্ট করছি, আমি মিউট করে নিলাম নিজেকে।
হ্যাঁ দেখতে পাচ্ছি।
আমি তো কথা দেখা গেলে কলকাতায় দেখা যাবে।
হ্যাঁ দেখা যাচ্ছে।
Okay, so we are talking about first we talked about the challenges of innovation, and then whatever we are talking today is ultimately understanding why do we need to protect innovation. Why I mean, why are you spending so much time? You invent, you create, very good, happy. So why do we want to get into this business of IP protection and all those things? So that's the key question. The whole seminar and everything is because we want to see whether. So I kind of think this is better. Yes. Why do we want to protect innovation? Why, otherwise, just do it. What's the problem? You create something new. You're doing it. People are doing it every day. Some of the reasons are, creativity is individualistic. It is ultimately the output of human intellect, the intellect of an individual or a group working as an individual, meaning group working together trying to solve a problem. So it's a very individualistic kind of an idea. So therefore, when you create something, you have your product against the whole world. The whole world today, if you have a great product, the whole world wants to have access to it, use it, try to see, I mean, get benefited out of it. So it's a David versus Goliath situation when you have your product which you have spent your efforts, your time, your money, everything to create something which is beneficial, something new which is beneficial to the society, and the whole society wants to use it, enjoy it. So what happens to your efforts? Unless it is protected by somebody who has the enough muscle power to ensure that everybody complies, your efforts will be nothing. Everybody will use it and you will not get any benefit from the efforts that you put in. So therefore, protecting this output of your intellectual endeavor is important to ensure that you get a fair deal on the efforts that you have put in. So that's the primary requirement why protection of intellectual property or protection of intellectual output is required. That you get a fair deal from the society for them to use the efforts that you have put in to bring something new to the market. So this is the primary reason why protection is provided. Disclosure is a one-way street. Anything which are tangible, be a product, the laptop, everything, you can say that this is mine. You can identify it as your product. It is yours. But the moment you speak about your idea, this presentation which you are seeing, it is marked as Zydus Cadila. So therefore, you can still say that this presentation was from somebody of Zydus Cadila. But what I am speaking now, can tomorrow, is there a way that I can say that, look, I spoke about it yesterday? This is the biggest problem, that once you disclose your idea to anybody, there is no way you can take it back. And because it is intangible, you cannot identify it as your own once you disclose it. Once you disclose it, it becomes everybody's property. So it's a one-way street. So therefore, before disclosure, it is important that you protect yourself so that others, you get a fair deal when you tell to others, that others can, that you have a way to identify that this idea came from you. So that's the reason why protection of your intellectual output is required. Ideas need time to develop and implement. You have an idea today, but you have to develop it. You have to see whether it works. You have to do the experiments. You have to test it. All of them takes time. Now, if you are not protected properly, by the time you have your idea, somebody else can do it better than you, quickly than you, and they've come to the market. And even if you had the idea, you are not in the market. So therefore, the protection provided helps you get that time to develop your idea, to ensure that you get a product, you're able to make the product, get the solution to the extent that you want, and nobody else is able to copy it without taking your permission. As I said, not all ideas will work, so therefore ideas will fail. So therefore, if you don't have protection, then why will you spend time in creating new ideas? If everybody copies you at the first instance, why would you spend time and efforts to create new ideas? Once you fail, you still try and get something you improve upon. Why will you put in that effort if you know that everybody will copy it and you will not get any benefit out of it? Valuing an idea is difficult. When you start with an idea, it's an idea. There are millions and millions of ideas. Of them, one will be that next billion-dollar idea, but it will take time and effort to get it. You'll know about the value of your idea in a future day, not today. So by that time, you need some level of protection to see that your idea matures into something which is valuable. And putting a value to the idea at a very early stage is extremely difficult. So you need that time to test your idea, to really see whether it is valuable or not. And society's progress is together with the development of your innovation, because every innovative product gives you a new solution to the existing problem. So therefore, these are some of the reasons, primary reason why we are talking about intellectual property, why talking about protecting it, is to ensure that every person who is a creative person, his or her creative output is valued by the society. He gets a fair deal from the society, that if society has to use it to benefit out of it, the innovator is not left behind. He also gets his due. The efforts that he's putting is recognized, respected, valued, and he gets proper value for his innovation. That's the reason why we are talking about intellectual property management. So that is why it is important that we understand the whole game. So go to the next slide, please. So intellectual property is the output of human endeavor, human mental endeavor. What comes out of your own mental effort is what intellectual property. It is not the product at the end. It is the mental output which results in the product. So there is a basic difference. A product is a tangible result which you get by using the idea which emanates from you. A product is the end product. The result is the product. It's a tangible thing which you see. But that product is a result of your creative endeavor. So intellectual property is not about the product. It is the property which allows you to develop the product. The creative endeavor, the creative output of your efforts is intellectual property. So it's a creation of the mind, inventions, literary and artistic works, symbols, names, images, designs used in commerce. IP includes but is not limited to proprietary formulas and ideas, inventions, industrial designs, and geographical indications of source, as well as literary and artistic works such as novels, films, music. So anything which is the creative output of human mind is covered under the definition of intellectual property. So anything, any endeavor which you do using your own creativity comes under the ambit of intellectual property. And for many companies, for many governments, IP is more valuable than all the tangible assets that they have. And IP loss, IP fraud is a huge problem. Somebody taking, I mean, as the reason why you need IP protection is otherwise people will use your ideas to get something, use your ideas and make money, and you will not be benefited. So therefore, this is some figure that loss of intellectual property is a huge problem. So understanding IP and playing the game properly is critical for us, our society to develop. So that's the reason why we need to understand this game of intellectual property. You go to the next slide, please. So when we're talking of intellectual property, these are, as I said, that intellectual property covers a whole gamut, whole wide year of what can of human endeavor. It could be a product, industrial product, it could be a design, it could be something of a literary work, novels, musics, all these things, and it could also be something of what one of your professor here to about something special about a particular origin or particular region that we're talking about, geographical indication. So these are some of the forms in which IP has been divided based on what kind of output your intellectual output is. That can be classified into these forms of intellectual property, and each has its own way of protection, each has its own laws, each has its own limitations. And you have to play the game understanding based on your what you want to protect. You have to play the game accordingly. You have to either file a patent application, file a trademark application, get a copyright, trade secrets, and others. Let's talk about all this. So these are different forms of intellectual property. Next slide, please. So copyright is something which the moment you create something, you write something, you create a music, you write a poetry, whatever you do in the artistic and literary and linguistic field is covered under copyright. So copyright is linked to mostly about your creative work in the field of artistic and creative endeavors. So writing a book, novel, poetry, music, your dance performances, all of this falls under copyright. Trademark, if you look at the right hand side, I believe all of you can identify each of the product as well as the companies that are marketing. Though I have not written the name of any company, merely looking at these symbols, these signs, these pictures, you will be able to identify the company and the product of that company. And that is what the trademark is. Trademark is something which identifies the product. It distinguishes the products. Let's say the first one, or let's say BMW. Every car is a car, but every car is not BMW. So trademark allows you to differentiate between similar products in the market. The moment you see that sign, you know from where it has come, you know what quality of attributes it is, you know everything about the product the moment you see that sign. That sign is a trademark. So it helps identify and differentiate a product in the market. The products may be the same generically, but still you identify a product and you want to have a product of a particular company, and that is the value of the trademark. Trademark allows you to identify a product with the source from where it has come, and therefore its attributes, some of the attributes which you expect because it is coming from that source. So that's a trademark. Design, it protects the shape and size and style. If you see the figure, this is a scooter, right? But is it an ordinary scooter? So it's something which attracts you, though it is the same product. If you go to a shop, you see tens and 15 types of chairs. You just don't pick up anything. You pick up a single chair which attracts you because of its shape, size, color, something which attracts you, though it is otherwise a generic product. So the design is something which allows, which helps you identify it attracts a particular product to you because of its particular shape, size, and other things. I mean, you all are fashion people, and you know brands, and the clothes you want a special type of clothes with all those. These are all designs, and then these are also protected because that's also a creative endeavor of person. You know, the brands, the people who are Sabyasachi and others who are those designers, and their designs sell in lakhs and lakhs of rupees because of the attractiveness that they bring to the otherwise same clothes. So that's the value of a design. Can we go to the next slide? So trade secret, we all know, I mean, this is the classic, the most important trade secret in the world, what's most commonly, the recipe of Coca-Cola. We used, billions of bottles of Coca-Cola is consumed almost every day, but nobody knows what is the recipe. And that's a trade secret. It is kept confidential, and therefore it is valuable, because the day Coca-Cola's recipe becomes common knowledge, the company will not exist anymore, because there will be thousands and thousands of imitators of Coca-Cola. So the whole business of Coca-Cola stands on the premise that its recipe is something which is not known to anybody. Not only Coca-Cola, be it your KFC or your McDonald's, the taste that you get is unique, and what makes that taste unique is not known. It is very closely guarded. That's trade secret, because the whole business is dependent on being able to keep that information confidential, and that's trade secret. Patent is something which is about industrial products or processes. When you make a new product or new process, you get a protection for patents. Geographical indication is something which was talked about, is something which is unique to a particular place, meaning it is something which happens normally. You get it normally in that place, like your Darjeeling tea. Tea can be cultivated at any place, but Darjeeling tea has its special flavor and taste, and that is unique to that place in Darjeeling. Tea is grown in Darjeeling, so nobody else can call their tea as Darjeeling tea. It cannot be that Assam tea, Darjeeling tea made in Assam. You cannot say that, because that tea is unique to Darjeeling, and this Darjeeling tree is protected under geographical indication, meaning that Darjeeling tea, this mark can be used only if the tea is grown in a tea estate in Darjeeling and adjoining areas. If the tea is grown in any other area, even if it tastes similar to a Darjeeling tea, it cannot be called a Darjeeling tea, because that Darjeeling tea, the term is protected as a geographical indication, and it can be only used for a product coming from that region. Similarly, Kolhapuri chappal. Kolhapuri chappal, even if you make a chappal which looks identical to a Kolhapuri chappal, you cannot call it as a Kolhapuri chappal, because Kolhapuri chappal the term is associated is that it has to come from the Kolhapur district in Maharashtra. So these are in the geographical indications, and these are protected, and these are very valuable protections. Champagne you cannot use any wine, you cannot name any wine as champagne, because champagne is geographical indication of a particular place in France. Only the wine which is formed, which is grown there and which is made there can be called champagne. So these are protected through specific protection is provided for products which are unique to a particular area, and these are protected under geographical indications. Can we go to the next slide, please? So, copyright is something which is it is a kind of a property which is created the moment your rights are created the moment you create something. You write a novel, you draw something, your copyright to that drawing or that novel is created at that point of time. It does not require any special kind of protection. You don't have to go to any office to get it registered. It exists, it is created the moment you create something new. And it gets the protection of the term of the author and 50 years from after his death. That's the period when during which the copyright exists. So therefore you see that Rabindra Sangeet was protected by was a copyright of Vishwa Bharati for a period of time, and now that copyright has now gone, and therefore everybody can now include their creative endeavors into Rabindra Sangeet, and we see all those newer versions of Rabindra Sangeet being created, which was not possible earlier because the copyright on Rabindra Sangeet was being held by Vishwa Bharati, and you had to take a permission of Vishwa Bharati to do anything with that. So therefore that is about copyright. Trademark, as I said, it could be a word, symbol, or slogan, like Toyota or this sign that we have here. The sign clearly immediately identifies it what we are talking about. We are talking about Mercedes cars. So just do it. It's the moment you see it, you know this is Nike. So therefore, it could be a word, it could be a symbol, it could be a slogan which helps you identify the product in the market. Or even this design, the Kit Kat design or the Tolmeron design, specific design. This even though it's a design, but this is also copyright. You have to keep in mind, a product can be covered by multiple kinds of IP. It could be protected by patent, it could be copyright, it could be trademark. All of them goes into a product. So therefore, it could be a product design also, or a slogan or a symbol which helps you identify the product from the source, who has made it. The moment you see this, you know this is about cars made by a particular company. So therefore, it gives a value, it gives a goodwill to the company. It helps identify, differentiate a product in the company. That's the role of a trademark. So can we go to the next slide, please? So like trademark, we also have service marks. Like trademark is for a product, service mark is for a service. Amazon.com is a service. It's not a product. It's a service. The way it provides you groceries and everything to you, it's a service that you get. This is the symbol of Australian airline. At one point of time, Australian airline was considered one of the best in India and in the world. Sorry, and this is a symbol which identified the airline to the people, knowing that if I fly Qantas, I know I'll get a particular kind of service, which was premium service I provided. MasterCard, again, a service. So service marks are something which identifies. Trademark identifies a product. Service mark identifies a service. Today we have a plethora of service. Uber, a company, Urban Clap. The moment you hear this, you know about what services they are providing. So that identifies the service maker, service provider, that okay, this service is now being provided by this company, and therefore I expect certain kind of quality out of it. So that's what a service mark is about. Next slide, please. So as I have said, the function of a trademark is it indicates the source or origin of goods or service, assures consumers of the quality of goods bearing the mark, because you know the moment you know you're Tata, you say that okay, if it is coming from Tata, it has to have a quality. You know, you expect certain level of quality from it. Creates business goodwill and brand awareness. As the first slide which I showed, the moment you see those brands, you know which product which you're talking about. It helps you create your identity in the market. So that's the function of a trademark. Next slide, please. Trade secret is something which, as I said, it is important because it is kept secret and it is valuable. So a trade secret is something whose value is because it is kept secret. Today, Coca-Cola's recipe is valuable because nobody knows it. Google's algorithm is valuable because nobody knows the algorithm. So the whole purpose of trade secret is you keep it secret, and because you generate value out of it. And the moment that secret becomes public, your value goes. The whole value proposition goes because your what was secret yesterday has now become in the public domain. And there is a cost associated with creating that trade secret. The recipe of Coca-Cola was created because somebody did a lot of experiments to have that particular flavor. So there is a cost associated with it, and the value is because it is not in the public domain. The moment it becomes in the public domain, you lost it. Your entire value proposition goes. The next slide, please. So we'll talk about patents. What is patent? Patent, as I said, protects any product or process, something which is new product or process that you have created is protected by patent. So patent is again, one thing which I just missed out is that all of these rights, as I said initially, that it is an individual creator versus everybody else who wants to use that idea. So therefore, the protection is provided by the state, be it trademark, be it copyright, be it trade secret. It is the state who creates laws to protect these creative endeavors of people. So it's the state which provides protection, creates laws for protecting it, and ensures that the protection is the person gets the protection. So therefore, there are legal remedies provided by the state to ensure that the protection is provided. So therefore, patent is a right issued by the government through the Intellectual Property Office for any technical innovation, a new product, a new process. If for that you are going to get a patent right, an exclusive right to use your invention for a particular period of time, and nobody else can use that invention for that period. Similarly, for trademarks, nobody can use that trademark as long as that trademark is used by you. So therefore, every kind of intellectual property right provides you with an exclusive right to practice your intellectual endeavor. So patent provides the intellectual rights to your innovation, to practice your innovations for 20 years from the date of your first filing. And for that, trade secret is something which is kept secret. Patent requires you to disclose the invention. So therefore, in order to get a patent protection, you need to disclose your invention so that others can use it, others can benefit from it. So once you disclose it, others will use it with your permission, but others can use it to make it better. They can do R&D with it. Those are allowed. We'll talk about it. So therefore, society benefits by disclosure. So therefore, patent right requires you to disclose your invention, how you made that invention. Everything needs to be disclosed. Right. Can you go to the next slide, please? So these are some of the considerations for patents. We have talked about patents, but this applies equally to other forms of intellectual property also. Patent rights are negative rights. So patent right does not give you, or any of the intellectual property rights does not give you a right to practice the invention. It gives you a right to stop others to practice the invention. If you want to sell a product in the market, you have to take several other permissions. If you want to introduce a drug in the market, you have to take the approval of Drug Controller of India to introduce the drug. So patent right does not give you a right to practice your invention. It's a negative right which allows you to stop others from practicing your invention. Second, patent rights are territorial, meaning if you want to protection in India, you have to get a patent registered in India. If you have to get a patent protection in Europe, you have to get it registered in Europe. So every country where you need protection, you have to go and get protection. There is nothing called a world patent. You cannot get a right everywhere by filing in one country. And patent laws varies with jurisdiction. Though there is a lot of similarity, but still patent rights varies with country to country, and each country has their own laws to protect the intellectual property rights of inventors and creators. So laws varies with country to country. So you need to know the law of the country if you want to protect it in a particular country. Patent right, this is very unique for patent right, is that you have to renew it by paying certain fees every year. If you want patent protection for 20 years, for every year you have to pay certain fees to all the patent offices to all the countries where you want protection. If you don't renew, your patent rights will be negated. You will not have any more rights. And obtaining patent right takes time. It's almost time and money. It's very costly. If you want protection in a couple of countries, the cost of obtaining this patent protection could run into several lakhs of rupees. And if you want in 20 countries, it could go into a couple of crores. So getting patent right is expensive. Move to the next slide, please. So what are the requirements for patenting? There are 3 requirements. It has to be novel, meaning it has to be new to the world. It should not exist earlier. It has to be inventive, that it is not obvious to anybody skilled in the art. I will touch about it a little bit. And third, it has to be useful. It has to have some industrial application. So patent rights is given to only industrial innovation. It is not given to other kinds of rights. So all inventions are inventions, but all inventions are not patentable inventions. So if an invention has to be a patentable invention, it has to satisfy these 3 requirements: novelty, inventiveness, and utility. Utility means industrial applicability. So what is classified as prior art? So your benchmark for getting a patent is what was known. Have you done something which is new based on what was known? So what was known is called as prior art, which existed earlier. And it could be anything, any information which is in the public domain. Any information in any way except oral, if it is in the public domain, that will constitute prior art. And if you do the same thing, what was already existing, you are not going to get a right. Patent right is only given if you create something new. So therefore, it has to be, and it is globally. It is not that what is known in India is only applicable. No, anywhere in the world, if it is in the public domain, that information is prior art, and your invention will be checked whether it is. And when I'm saying inventions, it is not only inventions, even your trademark will be checked with what was already known globally. And if it is known globally, then you're not going to get a protection under trademark also. So it has to be new to the world. Then only you get a protection under any intellectual property laws. Only for patent, there is a specific case that if it's an oral disclosure, it is limited to a country. What is known in India, we have so much of information about traditional knowledge in India. But if it is only orally known, then it is not protected in US. For any protection across the globe, the information has to be known in a written document. Then it constitutes prior art, what was known. Go to the next slide, please. So I think the most important thing for when you are trying to get any protection for any type of IP is to know what existed. Because Otherwise, you'll put in a lot of efforts and you will tomorrow see that whatever you have created was already known. And your entire effort, your entire whatever efforts on in getting that new so-called new IP will be wasted. So therefore, prior art search is critical if you know what is known in order to create something new. So therefore, the first is, why do you want to do a prior art search? So that you don't reinvent the wheel. You know whether your invention is unique or not, and you can know a lot of literature which can help you create a better product. How close are you with respect to the prior art? Whether it is so close that it will be considered as a routine extension of what was known. Am I required to license my invention? I mean, it could be that you're improving upon something, but that something is already somebody else's property. If you are improving, suppose you are making a new refill or a refill for a pen. Now, if somebody has a patent on a pen and you want to improve upon that, you need to get their permission. So therefore, it is important to know what rights exist before you get into creating your own rights, because your rights will maybe dependent on somebody else's right and you have a problem there. And you don't want to waste time and money in creating something which already existed, because it's a hugely costly process. So therefore, it's better to have know properly what is known before you start working on something which is new. And if you trespass into somebody else's property, that's a big problem. So can we go to the next slide, please? So we talked about it. Novelty means it has to be new. It has to be new to the world. And as I said, the day you file your patent application, the day you invent something, what was known prior to that is known as, will be prior art. And the date of your invention, the day when you invented it, will be considered as your priority date, the day which you created something new. So any information which is prior to it will be considered as prior art, and anything which is subsequent to it, your invention will be considered as prior art. So therefore, this priority date is very important, because this is kind of a border, what was known and what was new. So to define that, priority date is the border, the day you invented is something. Based on that, your invention will be checked whether it satisfies the requirement of novelty, inventiveness, and utility. Go to the next slide, please. So novelty means it has to be new. In this example, if a three-legged tool was known, the four-legged tool will be considered new because there was no information of a four-legged tool. So novelty means the moment you do something which is not there, which was known earlier, you satisfy the requirement of novelty. So anything new that you create is novel. So but for getting a patent, you have to satisfy three requirements. First is novelty, second is inventive. So the four-legged tool will be considered novel. It is new over what was new. Let's go to the next slide, please. Can we go to the next slide?
Arunima, next slide. Yes.
So first is novelty. The second we said is obviousness. So whether the invention as a whole was something which was routine, can be considered routine based on what was known. The earlier example, the three-legged tool was known. What you did was you just put in another leg to it. So people may consider that this is something which is routine to a person skilled in the art. Now, what is a person skilled in the art? It's somebody who is in that field. So a carpenter looking at a three-legged tool would consider putting another leg as a routine thing so that it increases the balance. So if your invention is something which is considered as obvious, meaning it is routine extension of what was known, and this is another example which I put in. If you attach a clock with a radio, so that you know that, okay, at 9 o'clock I have a special program which I don't want to miss. And how do I ensure that? I put a clock on that radio so that at 9 o'clock you see that, okay, 9 o'clock, it is 9 o'clock, I switch on the radio. So putting a radio to a clock clock on a radio first time would be considered novel, but would be considered non-obvious, special? Maybe not, because you had a problem and the obvious solution to that problem is I put in a radio and a clock together. So you know exactly what is the time and you can switch on the radio. So if it is considered obvious, then you will not be a patentable invention. So this is the second requirement. So how do you satisfy this obviousness and how do you look at obviousness? There are some examples. Can we go to the next slide, please? So if your invention is unexpected, it does something which the other prior art did not. So look at the figure. It from a coal-fired engine. Can you think of a diesel-powered engine? The first day when it was invented. This could be considered as non-obvious because nobody would have thought that you could replace coal with diesel. The first time a diesel engine was, not today. So you have to think about the day when the invention was made. At that day, this could be considered as non-obvious. Why would somebody change from coal to diesel? What was the motivation? So, and this is an unexpected result. And this coal-powered engine, the small one, could have pulled only 2 or 3 bogies, but these diesel engines now pull almost 30-40 bogies. So there is a huge unexpected result, and there is a huge utility. So if these conditions are satisfied, then any invention may be considered as non-obvious. Can you go to the next slide, please? Commercial success from a single-seater aeroplane to today's commercial airliners. That's a huge, even though both are airplanes, but there's a huge difference. So there's a huge commercial success. Long felt need because people wanted to fly and many people wanted to fly. So therefore jetliners solved that problem. And we know, making a jetliner was not easy. The first time the jetliners were made, so several companies failed before we had a commercial jetliner. So all of these are some of the criteria based on which an invention is considered, whether it will be obvious to a person or it will not be obvious to a person. If it is non-obvious, and it is novel, then you will get a patent. If you fail that, then you will not. That can be an invention, but will not be a patentable invention. We'll go to the next slide. So this is the third requirement. As I said, these patents are for industrial innovations, and therefore you have to show some usefulness. And now, when I say usefulness, it is not required that it has to be commercially useful. You have to show some utility, some benefit of the invention, because it has to be industrially useful. So you have to show a benefit for the invention. But it is not required that it has to be commercially successful only, then you get a patent. No, it is something which has to have some utility. Go to the next slide, please. I think we can skip this because this is a slide which talks about how you get a patent, but again, this would require a lot of presentation here. So this is something which I think is important because I'm talking about to academic section here. So whether you want to file a patent application or you want to publish it is a question which comes up quite often. So we need to think about, if you got something new, whether it is something which is commercially viable, then you would file a patent application. And if you think that it will help add to the body of knowledge without any commercial benefit, then you can publish it. So these are some of the questions which you can think about. So if your technology is commercially viable, if you think that there is a commercial use to it, then you should go for a patent. If it is for knowledge sharing purpose, please publish it. So what are the rights granted? If you are a patent, you get an exclusive right to stop others. Publication, you get a copyright. Nobody can copy your literary work, but they can build on that. Patenting requires a legal procedure. Copyright, I said, publication does not require a legal procedure. You need to go to a publisher and get it published. But for getting a patent, you have to follow a legal procedure for getting those right. Cost for patenting, the cost is high. Publication, normally the cost is low. Who uses the technology? Patent, only the patent holder can use it or his licensee. Publication can be used by anybody. Technology protection. Patent provides protection for the technology. For an article, only the text of the article is protected. The same idea can be used by somebody else and they can write a new paper. There is no problem. Financial gain, patent use, there is a possibility of financial gain. Papers, I don't think that there is much of a financial gain. Disclosure, a patent is disclosed after 18 months. It is published. And a paper is published almost immediately. Once it is peer reviewed, it gets published. So therefore, there is no fixed time for publication. But patent, there is a fixed time that after 18 months of your first disclosure, of your first filing, it gets published. So there is a legal process to it. Go to the next slide. So these are some of the questions which you can ask before whether you want to patent it or when you want to publish it. And if you want to patent it, is it worth spending money getting a patent? Because patent requires cost. There's a substantial cost. So if you want to patent it, these are some of the questions which you need to address and see where do you stand. What problem does the technology solve? Is it solving a really important tech problem? Is the technology useful? How many players can I block? So as I said, the patent right is about stopping others. So therefore, is your process or product something which others will be interested in? Whether they would spend money to copy your invention. What is the competitive advantage? Is there a market? Because you'll be spending money getting a patent, and if there is no market, you will not recoup that money. How long will the technology will survive in the market? I gave an example. Even Bill Gates could not predict the future technology. So how long will it survive? Or somebody else, some competitive product will come in and they will take up your market share. What is the cost involved? Manufacturing cost. Then which countries are in my market? Where do I want to file this patent application? Where do I want to get this protection? So a lot of questions needs to be asked before you decide to patent an invention, because a patent being an invention is a huge cost. So therefore, before you need to really do a proper prior art search to see where you stand and how much is the costs involved. Next slide, please. So innovation doesn't stop. Innovation is a continuous process. This is a classic example. If you see, even a paper clip requires, you see the first patent was in 24 and the last identified year is in 2006. So it's almost a 60-70 years journey and an innovations is going on, and we are going, and you need to, as you innovate, you need protection. So I'll stop here because I see I've spent almost an hour. There are a couple of slides at the end to cover the other part, but if there is time, I can continue, or I can stop here because I've actually at least covered the reasons why you need to protect your innovations and some aspects of the intellectual property. Take questions.
Any questions from the participants?
Hello. Hello.
Ah,
Shall we start?
yes, you are audible.
Yeah.
Yeah.
Then shall we start the interactive session?
Yes.
Okay. Thank you, sir. That was so very informative. I mean, I don't really have enough words to describe how very helpful it's going to be for students, teachers, researchers alike. I mean, this is really a very complicated field, and you made it like so easy for us to understand today. So thank you very much. Uh, and we will now take up the questions from the audience. I would like to request Miss Arjoma Chakraborty and Ms. Madhurita Shaha, faculty members of Department of Microbiology, Sammilani Mahavidyalaya, to conduct the interactive session. I think there are some questions in the chat box.
Orunima, one question. Before we start the interactive session, I would like to ask Dr. Banerjee that is there any other slide you want to show us, or would you like to stop here? I mean, what about that?
There are some such slides, but that was what I planned. Actually, was this was the part about protecting innovation, and the other a couple of slides on if you want to make a copy of an existing product, the things which you should be taking care. So maybe another 5-7 minutes, but I just stopped because I saw I finished my scheduled time.
Okay,
And
that
I
is
don't know.
fine, but you can continue for another 10-15 minutes. Arunima, what do you say?
Yes, sir, you can.
You can, yes. We were, I mean, very interesting, and we were listening to it very.
Yeah, you were so engrossed.
So
And
I think you can continue for another 10-15 minutes, and then we can go back. I mean, go to the interactive session.
I don't know because it's almost lunchtime, so
Doesn't really. It's perfectly okay. We are all at home, so another 15-20 minutes won't make much of a difference.
Yes, sir, please. If it is okay with you, of course.
Yeah,
I'm
I'm
so
okay.
engrossed in listening.
I'm okay. I mean, as
Okay,
long
then-
as there is interest, I hope there is interest because I don't
Yeah,
know,
it's-
I'm not able to see anybody. So
So it's so interesting. So I'll resume the presentation for another 10 minutes. Then you
yeah, 10
can
minutes should be.
go on.
Should be.
Yeah, then we can start on with the interactive session. Arjuma and Madhurita, you can wait a bit later.
Yes, ma'am.
Yes.
It's okay. Thank you.
দেখা যাচ্ছে?
Ha.
Clear.
So till now we talked about innovations and innovative products and getting protection for innovative products, ideas, I would put it. When I'm saying, see, I'm a patent guy. I don't do too much of trademarks and other things. So whatever I talk is mostly with respect to patents, but this applies equally to the other forms of intellectual property also. So whenever you create something new, you need a level of protection, and there are ways to get the protection. So and each kind of intellectual property provides you certain types of protection, and which you need to understand and use it properly. So that's about innovation and innovative products and things like that. So but especially country like India, we are a generic hub. Now if you talk about pharmaceutical sciences, we are considered the pharmacy of the world because we are the country who can produce almost any product at a price which is affordable globally. Just think of the vaccines again. I'm talking about COVID because this is something which is quite significant, and all of us are into it today. We are doing 1 crore jabs a day. Think of the process innovations which has gone in to ensure that so many vials of vaccines are being prepared every day for us to vaccinate, and we're now saying that we have now scaled up our capacity to an extent that we can provide our vaccines to the other countries. And when we produce, actually, when Indian companies start exporting, the world will get vaccines. Whatever numbers we are talking about coming from US and Europe and all those are some drops in the ocean. The world will get vaccinated only when Indian companies start exporting these vaccines. And that's so that what has been prepared is actually copy of the AstraZeneca vaccine. Today, whatever we are using mostly is the AstraZeneca vaccine. At some way there is a technology transfer and Serum Institute is manufacturing, and that's something. So therefore, it is a copy of an innovative product. Serum Institute did not innovate this product, but they have increased their capabilities in process research in such a way that they can scale up and produce these vaccines to an extent. Even the Russian vaccine, which now is being prepared and probably come to it is already in the market, but in the next month I will see it's several the scale of Russian vaccines coming in, going increasing substantially. So that's when even making a copy of an existing product is where India's strength lies, has been historically in most of the fields. So when you are making a copy of an existing product, it is not a free way. It's not a free way because innovators have their own IP, and you have to ensure that the products that you make is not getting into trespassing any of the innovators' IP, innovators' IP, be it trademark, copyright, whatever. So some of the challenges which you're making in the generic products, and I'm now focusing mostly into pharma because that's what I am from, and I think most of you maybe tomorrow going into some way into biotechnology, pharma, and spaces in your career. So you can possibly launch any generic product only after all the patents of an innovator of covering that product expires, meaning after the expiry of the rights of the innovator. As an example, adalimumab is the world's largest selling molecule today. It sells almost $20 billion, $20 billion a year. It's a humongous product. And in US, the originator has more than 300 US patents. So anybody wants to make a generic equivalent in adalimumab and want to sell it in US has to ensure that those 300 patents, they are out of the scope of those 300 patents. So making a generic product, the biggest challenges is that you have to ensure that you don't trespass anybody else's property. That means you have to have a freedom to operate. So innovators and other companies, not only innovators, see, if a patent has a life of 20 years. So if it's 20 years, many people will be trying to improve upon it. And they would be filing their own patent applications. So you have a patent thicket. You have a huge number of patents. Adalimumab 300 innovators. So there will be another 600 to 700 of other people's patents, other companies' patents. So if you want to launch a generic, you have to ensure that you don't trespass any of those 600, 900 patents. And it's a tough job. It's a tough job to do that, but you have to ensure that you are doing it. Otherwise, you will be caught and you will be going to the court and fighting cases. They will sue you. They will sue you for infringement, and they will say you that you are trespassing my rights, and therefore they will stop you. All your efforts will go because you will be stopped from marketing your product. Other challenge is crowded market with multiple companies. Everybody wants to make a copy of adalimumab because adalimumab is such a big product. So, and there is, because you want to make a copy of the existing product, there is very little differentiation that you can bring in because you have to copy that product. Innovation means you can bring in a new product. There is no benchmark. Here you have to exactly make the same copy. Then only you become a copy. So, and that's a big challenge. So because the innovative product was made 20 years earlier, and you are trying to copy it with a 20-year new technology. Let's say for any of these maps, you test these maps in various assays, right? So the assays which were used to test adalimumab in maybe 1996, 97, if you are trying to make adalimumab today and you have to show that it works similarly, you have to do those assays. You may not have those assays today. Many of the assays don't exist today because this is so old technology. And that is another big problem when you're trying to copy. because the tools for making the product may not exist today. Think of it, you want to make a better typewriter today. Will you get the tools to make a better typewriter? You will not get the tools. So that's another problem with making a generic. Cost of competitiveness. You have to compete on cost. Generics normally compete only on cost because the moment they make something different, it's a new product. If you are making a copy of an existing product, the primary differentiator is cost. So you have to all continuously think about reducing cost, and you have to reach the market. You know, one of the products recently last year we launched in India was vildagliptin. It's an anti-diabetic drug. The first day when generic vildagliptin was launched, December 2019, there were 72 players in the market the first day. 72 generic players in the market with vildagliptin on the first day. And think of it, you are coming after 7 days. You will not have a market. So therefore, speed to the market to ensure that you are among the first of the copycats is essential. So therefore, making an generic product apparently looks easy, but it is not. It has its own sets of challenges. And one of the primary challenges where IP is involved is to see that you don't trespass somebody else. So can we go to the next slide, please? So from IP perspective, the biggest challenge for making a copy of an existing product is what we call as infringement, that you are trespassing somebody else's property. And this is a real problem, real challenge, because if you get into somebody else's shoes, you are in big trouble, big legal trouble, because you'll go to the court. Court will stop you from not only manufacturing and marketing, you will have to pay damages. And that damages in India, it is also increasing. I mean, it's now going into crores. In US and other companies, the company you will get broke by paying the damages if you infringe somebody else. So what is an infringement? That basically, if you are as I said, IP rights belongs to the owner, and owner has a right to stop others from using their IP. So if the owner allows you to use it, you can use it. If the owner does not allow you to use it and you are using it, then it is a case of infringement. So what is infringement? It is the without authority, means without the permission of the owner of the IP. Anybody who makes, uses, offers to sell, sells, or a patented invention within the jurisdiction where the IP rights exist. As I said, IP rights are territorial. So therefore, wherever the IP rights exist, if somebody makes, uses, sells, offers to sell the IP protected product or process, that will be a case of infringement. And infringement can happen by making without selling or using without making or selling, any of these acts which you take, any of the actions if you do, sell, use, make, or offer for sale or import a patented or an IP protected product will be cased. Okay, I saw the question. I'll touch about it. So let's do it quickly. Can go to the next slide. So for a patent, when you will be infringing, if there is a patent term, as I said, patent term is for 20 years, and the 20 years, if you are making, using, or selling a patented product within 20 years, it will be an infringement. And the patent is being maintained. This is very critical, and this is something which actually we even professionals like us sometimes miss out. Is, as I said, the patent has to be rights has to be renewed every year, and if it is not renewed, in that case, the right goes. And if it is not renewed, everybody is allowed to use that invention. Can you go to the next slide, please? So when will infringement not occur? And this is important from an academic point of view, that if you are doing it, if you are copying an existing of a patented product for research purpose, for your own use, then that is not a case of infringement. So if you're doing it for non-profit purpose, then it is okay. If you're filing for regulatory approval, you want to get certain approvals for doing some tests, so that is allowed. The last part is somebody doing it in a ship, and this is a specific case. It came for because of some cases which came up some in historic times. If you are copying an invention in a ship and that ship is in Indian waters, then that will not be a case of infringement. So basically, if you are doing a work, if you are copying an existing patented product for research purpose for your personal use, then that will be not considered as a case of infringement, but otherwise it will be a case of infringement. Let's go to the next slide. Or if you have bought the product from a registered authorized seller. So if you have bought a computer or an iPhone from a registered vendor, then using that product is not an infringement. As I said, patent rights are territorial. So therefore, if a patent is not there in India, a patent is in Europe, using it in India is okay. And the last, and this is important. This is also important. If you can show that the patented product was inherently present from what was known in the prior. An example: suppose you have claimed a metabolite of a product as a patent. Now, if I show that metabolite was formed inside the body when somebody took a drug earlier, then that patent, the claim to the metabolite will fall. So therefore, that metabolite will be considered as an inherent outcome of taking the drug earlier. So that is another case where you don't infringe a patent. We'll go to the next slide. So these are the two types of infringement broadly. If you make the patented product, then you will be infringing. That is direct infringement. The product is there and you copy the same product. It's a direct infringement. The indirect infringement is when you don't make the product, but you supply the ingredients for somebody else to make the product. Meaning, suppose there is a pen which is patented. What you do is you supply each of the components of the pen, the refill, the head, and the copying the product, but not make the final product. The person who is writing is making the pen. He just assembles the pen and makes the pen, assembles the parts and make the pen. So the person who is using it is infringing, and the person who is supplying those components will be indirectly infringing because they are providing the ingredients for somebody to infringe, and that is indirect infringement. So there are two ways of infringement. One is directly you infringe, making the same product, and two, you don't make the product, but you provide the means for somebody else to infringe. That is also not allowed. So these are two ways of infringement. Go to the next slide. And this is the third, and this is where most of the problems happen, is that, okay, I see the patent, I see the product and say, okay, I don't want to make the product, but I want to make something different so that I don't get into the patented product. I don't make the patented product copy, but I make something which is a small difference. Meaning, if let's say for a compound there is a chlorine present, and you say, no, the product has a chlorine, I don't want to make chlorine because then I'll be infringing. Let me be innovative. I make a bromine there. I use a bromine there. But it does the same job. It will do the same job. It will still act as an insecticide if the original product was an insecticide. Now, that means what you are doing is not the same product, but an equivalent product by simply getting out of the specification of the product, and which is going to do the same job, the same way, everything will be the same, but you are not making the same product. No, that is also not allowed because that will be considered as infringement under doctrine of equivalence. So these are the three ways we need to keep in mind if we are trying to get into making anything which is commercial. One, we have to take care of the innovation. The other which we need to take care is about ensuring that while innovating or trying to make a product, we should not be trespassing somebody else's property, because that's a very, very big problem and a big challenge. Because if you end up doing that, not only your entire efforts, because the court will stop you from marketing the product, so your entire efforts in developing the product will fail. Not only that, you will be also asked to pay damages, and that damages could be very, very substantial. So that is another aspect which we need to keep in mind when you are into the business of creating any product, whether it is innovative product or a domestic or a copied products. So I'll stop here, and I would just talk about. I think I saw that question. Dr. Sharmila wants me to talk about the career aspects. So let me. I mean, this may not require a slide. So you see, as an IP can be used as a career in two aspects. One, tomorrow if you go to the industry or academics, anywhere you go, knowledge of IP is today essential, critical. I mean, it's there is no way you can live without it, because anything that you do will require you to have a good understanding of the IP space, of IP, what exists. So therefore, one, your understanding of IP will be very important when you go out and go to the industry and say that, okay, I want to be a researcher. You will also be asked questions about your knowledge on IP, whether you know how to play the game. That's something. So therefore, knowledge of IP is critical, not only as a profession per se, but any profession in the industrial space. If you want to pursue, your knowledge of IP will be very, very important. Now, as a profession, whether I can take up IP as a profession. Absolutely. See, IP requires technical knowledge, technical information. The people who are with me I don't choose lawyers in my field, in my team. I choose people with PhDs in chemistry, biotechnology, microbiology, because if you are talking of inventions, you are talking of cutting, you have to understand cutting edge technology. You need to understand what is new. So you need to understand the technology space very well. So people who are technologically oriented are people who are needed, and we have a huge need. We don't have enough people with technical background who can today take up or are becoming IP professional, who prosecute patent applications, who draft patent specifications, who can argue matters in court, who can argue matters before patent office. If you want to argue matters before patent office, you have to be a patent agent. Now, being a patent agent requires you to have a technical degree. So, as you can become a patent lawyer, you can become a patent agent, you can join any industrial company in the intellectual property field. Today, every company requires IP person. Even if he is making the oldest of products, still that company has to ensure that he is not trespassing any of the existing technology. And if he wants to improve his margins, improve his business, innovation is the key. And if he or she is innovating, he needs an IP professional in his organization to ensure that his IP is properly protected. So therefore, there is a huge requirements in India, and it is growing by the day. As India slowly is becoming more and more innovative, the demand for IP professionals as an in-house expert, as a patent agent, as a lawyer, and also as judges. Today, we don't have specialized patent judges because our judiciary today does not have too many people who who are technically qualified. If in countries like US and Europe, there are specialized patent judges, technical judges who mans patent courts. So it will come in India also. So all of them would require people who are technically qualified, who come in this profession and make a career for themselves. So there is a lot of possibilities for you people to also look at IP as a profession. I'll just give you an example of what I went through, and then I'll stop. Maybe that will give you. In 2001, 2002, maybe Dr. Sharmila would be remembering, I shared this experience. Whenever there was a seminar happening, an international or national seminar happening in Gujarat, in Delhi, and other places, I used to go and put up a tent saying that I have a vacancy in my department in IP. Please join me. I used to prepare. I prepared pamphlets to share with students, talking about that IP as a profession you should take up, because I did not get people to join my department. Only people who were rejected everywhere used to come in IP. So that was 2000, 2001. Today, if I give an advertisement that I need a person in IP, I will get 50 plus CVs immediately. So people are getting interested. People today, many of the youngsters are coming to IP because there is a future there, because there is so much which can be done there. You can be, and another area, I mean, where you can work is in the techno-legal areas of out licensing, in licensing, business. If you have to sell a technical product, you need to understand technology. So even today, if you have to sell your product well, even in the marketing, you need people. If you are making an innovative product, you need people who understands and are able to explain the new product in the market. So you need people with technical backgrounds as a techno-legal marketing people also. So IP, knowledge of IP and an IP as a career, you can use it in multiple fields.
Thank you, Dr. Banerjee. I think, Arjuma, you can proceed to the next questions.
Yes, ma'am. Good afternoon, everybody. Thank you for giving the opportunity to conduct the interactive session. And on behalf of the webinar organizing committee and the participants, we would like to give a brief idea. Dr. Banerjee, who gives us a very clear idea about the IP and the intellectual property rights. And without wasting time, I just go to the question from Lupsi Mohanty Roy from our college, Sammilani Mahavidyalaya. She gave two basic questions. Is there any limitation on number of patents in individual or organization can have at a point of time? And the second one is, in case of a life-saving drug which is needed immediately, what is the duration taken to get the patent, or normal time period taken to get a patent?
Okay. See, if the more innovations you do, the more patents you have. So there is no limit to the numbers. And believe me, if you look at IBM and Microsoft, they file at least thousands and thousands of patent applications in a year. There is no limit. I mean, the more innovative you are, the more patent applications. Even a company like Zydus today, we file at least 70 to 80 patent applications in a year. So there is no limit.
No,
That's the first question. Answer to the first question. The second question is, see, let's not complicate our IP space with life-saving and other things. Patent right is purely a single. It gives you only one right. That if somebody wants to use your invention, they should ask your permission. Nothing else. That IP right is not nothing else. Very simply, it is, if you have invented something and somebody else wants to use it, they should seek your permission. That's what IP is. Now, about life-saving drugs. Now, remdesivir is something which we have been using so much. even the vaccine, we are talking about this Covishield vaccine. See, these were invented by somebody else. Remdesivir was invented by Gilead. Covishield was invented by AstraZeneca and that University of Oxford. In India, we have Remdesivir now being manufactured by so many companies. How? Because Gilead gave a license to Indian companies to manufacture it to meet Indian people's demand. So companies, including Cadila, went to Gilead, said that give me permission because this drug is needed for patients in India, and we will want to manufacture it. Give me permission. Gilead gave the permission, and we are all manufacturing it. So life-saving or anything which you need, patent right only simply says that please ask the permission of the owner before you use it. And the owner can say, ki, boss, I have spent a couple of crores in developing it. I need some ROI, some return on my investment, right? So you have to give me some money. Or he may say that, no, fair enough, because now there is a pandemic, I don't want anything. During the pandemic, please use it. I don't need any license. After the pandemic is over, if you still want to use it, then I need some money for my investment. I think that's a fair deal, right? So I think that's the way this whole business is.
Thank you, sir. And the next question, can Madhurita read it? Hello. Okay, then I'm going to. It's from IQAC Raidighi College. It's about you are talking about a specific geographical watermark in products like Kolhapuri choppal or champagne. When we take a product out of such specificity and broadly tag it under a geographical location like Chinese food or Thai food, etc., being served worldwide, like South Indian food, it's going to be served across India. How far are these tags in their proper right to be called so? Does that same geographical validation hold true for these larger uses?
See, this Chinese food and Japanese stuff are our way of explaining stuff. These have been created by our imagination. This has nothing to do with geographical indication. Geographical indication means it has to be specific to a particular area. See, tea is grown across the world. Coffee is grown across the world. Can we call tea grown anywhere in the world as Darjeeling tea? Why? Because if it is big, why is it not so? Because teas, we know, I mean, Assam tea has a taste different from Darjeeling tea. Nilgiri tea tastes different. If I bring in a tea from China, Chinese tea tastes different. Japanese tea tastes different. Each of them tastes different. We know that. Now, that taste which we get from the tea in Darjeeling has some unique features, which is found great by people around the world. There is a special value of the tea coming from Darjeeling, and which people like. Now, if everybody's tea is said it is Darjeeling tea, what will happen? We will stop taking Darjeeling tea because we'll be frustrated that I'm getting all trash in the name of Darjeeling tea. Now, how do we ensure that people will, and therefore the people of the tea people and the persons in the tea estate of Darjeeling who has been making that tea will suffer? Because their market of this exclusive tea will be lost. So how do we ensure that that those people are protected, that nobody just copy says any tea as Darjeeling tea. So that is where the protection, geographical indication protection comes in, saying that if you have to say that this is Darjeeling tea, means that it has to have certain attributes, and these attributes you will not get in any tea except the tea which is grown in Darjeeling. So that is where these geographical indications are protection are provided for specific places to ensure that those products are not generalized and every tea becomes a Darjeeling tea, and people stop taking tea. This Chinese food and Japanese food or Thai food is these are our, whatever we say. If you go to South India, they may not call it Chinese food.
Yes.
Or if you go to any other country, they may not call it as Chinese food. They will probably say something else. So those are not geographical indications.
Thank you, sir. I think we don't have any more questions. Can we proceed, Purnimadi?
Okay, thank you, Arjava. Thank you, Madhurita. And thank you, Kaushikda. Thank you again for patiently answering the questions. So, Shamila Di,
Yes, হ্যাঁ বল।
আমরা তাহলে নেক্সট ভ্যালিডেটরি সেশনে চলে যাই।
হ্যাঁ, ভ্যালিডেটরি সেশনে চলে যাই।
Okay, so we will proceed to our valedictory session. I will post the feedback link in the chat box. Please fill up the feedback form. May I now request Ms. Pamela Dr. Roy, Faculty, Department of Microbiology, Sammilani Mahavidyalaya, to deliver the vote of thanks.
Thank you, Arunimadi. Am I audible?
Yes.
Honorable dignitaries, distinguished guests, respected principal sir, and dear participants, on behalf of the webinar organizing committee of Sammilani Mahavidyalaya and Raidighi College, I feel immense pleasure to take this opportunity to propose a vote of thanks to our eminent speaker, Dr. Kaushik Banerjee, General Manager, Zydus Research Center, Ahmedabad, who spared the time of his busy schedule to grace this webinar with his extremely relevant address on intellectual property right. He rightly talked about innovation, which is an individual's or group's own effort, and this creativity, or rather to say intellect, must be protected. Sir, indeed, your words are very helpful to our students and as well as us. You have made us easy to understand this difficult topic. I take this opportunity to specially express my deep regards and gratitude to Dr. Shantiranjan Pal Choudhury, Principal, Sammilani Mahavidyalaya, and Dr. Shoshobindu Jana, Principal, Raidighi College, for their constant encouragement and support. I extend my sincere thanks to the IQAC coordinators of both colleges, Dr. Srikanto Malakar and Dr. Shishir Chatterjee, and IQAC members, college seminar committee, microbiology faculty members of both colleges for their enormous cooperation. My deep sense of appreciation and thanks to all the participants who chose to be live with us and attended the webinar with great enthusiasm and made it a successful event. I would also like to thank the organizing committee for taking that relevant topic. Last but surely not the least, a special thanks to IQAC faculty members of Raidighi College, Mr. Shanut Kumar Purokait and Mr. Shubhankar Ghosh Roy Choudhury for their advice and technical support in live streaming of this session. Once again, I thank you all for being with us and wish a good afternoon. Arunimadi?
Thank you, Pamela. All participants are requested to fill up the feedback form. The link has been posted in the chat box. So our journey today is almost over now. Thank you all once again. Stay safe. And over to you, Shomiladi, to officially say goodbye for today.
Once again, a very big thank you to Dr. Kaushik Banerjee for his very informative speech. And moreover, you have taken out time of your busy corporate schedule for this webinar. We are very thankful to you. As Pamela said, you really made a very nice presentation in which IP could be made simpler. And I hope the students have had knowledge of, I mean, some information and they have understood parts of it. And maybe in class, we will have more questions regarding this, which we will be able to maybe solve. So I think this was a successful initiative, and in future we will be able to hold more webinars like this for the benefit of our students as well as other faculties of the different colleges. And now we say goodbye. Please take care in this pandemic situation. Stay safe, stay healthy. Goodbye, all.
Thank you. Thank you very
Purnima,
much.
Thank you, Kaushik da. Thank you so much. Thank you, Shomila di. Thank you,
হ্যাঁ,
everybody.
থ্যাংক ইউ সো মাচ।
আমি আরো একবার ফিডব্যাক লিঙ্কটা পোস্ট করে দিচ্ছি, তিনবার করলাম এই নিয়ে, যাতে সবাই দেখে নিতে পারে। If you don't get your certificate by the next 2 days, then please do contact us.
Thank you, everybody, for your precious time. Hope we'll meet again for a next seminar.
সবাই লিভ করলে আমি এন্ড করে দেবো।
হ্যাঁ, সবাই আমার মনে হয় ফর্মটা ফিল আপ করুক সবাই
হ্যাঁ
বোধহয়।
হ্যাঁ, ওই জন্য আমি একটু রেখেছি।
হোল্ড করি আমরা একটু। অরুণিমা গেল।
হ্যাঁ বলো।
বলছি কি, যারা ধর এই যেরকম শ্রীকান্ত তো রেজিস্টার্ড নয়, ও কি ফিল আপ করলে তো ওর কাছে সার্টিফিকেট যাবে তো নাকি? না
হ্যাঁ
বল।
হ্যাঁ
হ্যাঁ যাবে। বুঝলি। মোটামুটি তো সবাই লিভ করেছে।
হ্যাঁ এই আমরা দুটি বাকি থাকতে তারপরে বেরোবো।
হ্যাঁ
কারণ শুভঙ্কর বোধহয় আরেকটা ওয়েবিনার জয়েন করেছে, মানে ও
আচ্ছা।
অফিসিয়ালি এন্ড করতে পারছে না।
অর্পণ তুমি এখানে? ওই অর্পণ লিভ করে গেল। অর্পণকে জিজ্ঞেস করতাম না হলে কিরম লাগলো।
আমার তো খুব ভালো লেগেছে, স্টুডেন্টের মতো নোট নিচ্ছি না।
নোট ও আমাকে, আমি যখন আইপি পড়াতে শুরু করেছি গত বছর থেকে, আমাকে সব পাঠিয়ে দিয়েছিল এগুলো।
আচ্ছা আচ্ছা
বই, একটা খুব ভালো বই আছে, আমি পাঠিয়ে দেবো তোকে। আইপি,
Okay.
মানে সেখান থেকে ইন্ডিয়ান আইপি সব ইয়ে করে পড়ানো যায়। হি ইজ
আচ্ছা,
ভেরি থরো অ্যাকচুয়ালি, হি ইজ
হ্যাঁ
ওয়ার্কিং
হ্যাঁ
অন ইট
হ্যাঁ
ফর দ্য লাস্ট
ভীষণ
20
ধরনের
years,
আছে।
তো হি ইজ ভেরি থরো।
বোঝাই যায় ওনার বলার এটা থেকে।
হ্যাঁ হ্যাঁ, মানে খুব অথরিটি আর কি এটার ওপর।
আচ্ছা আমার মনে হয় সবাই পেয়ে গেছে।
হ্যাঁ হ্যাঁ হ্যাঁ।
আমি তুমিও বেরোই।
কৃষি রয়েছে নাকি আইকিউএসি রায়দিঘি কলেজে?
ওইটাই শুভঙ্করেরটা।
ও শুভঙ্কর।
ওটা দিয়ে, হ্যাঁ
আচ্ছা আচ্ছা।
শুভঙ্কর আছে। ও পরে ওয়েট করে দেবে।
অঙ্কিতা সৌমাশিস, আচ্ছা অঙ্কিতা চলে গেছে। শকুন্তলা আর সৌমাশিস, শকুন্তলা ঘোষ, উনি কোন কলেজের?
বোধহয় আমাদের কলেজের পল সায়েন্সের একজন আছে।
ও ফ্যাকাল্টি। আচ্ছা। সৌমাশিস আমাদের ছাত্র।
আচ্ছা আচ্ছা।
ওরা রয়েছে।
আমার মনে হয় আমি আমাদের
হ্যাঁ এন্ড করে দেব।
দিলাম এবং প্রায় 37টা এসে গেছে অলরেডি।
আচ্ছা আচ্ছা
37 রেসপন্সেস।
ঠিক আছে, আমার মনে হয় লিভ করে এবার, হয়েই তো গেছে।
আমি লাস্ট আরেকবার টাইপ করে দেবো, দিয়ে আর
হ্যাঁ হ্যাঁ।
বেরিয়ে যাচ্ছি। টেকনিক্যাল প্রবলেম হয়নি বেশি, এই
না
ভয়েসের
না না,
ওয়েদার কেমন
হ্যাঁ মোটামুটি কভার করা গেছে, কিন্তু অনেকেই জয়েন করেনি, সেটা একটা মানে
হ্যাঁ
এটা হয়তো আজকে অনেক প্রবলেম হতে পারে, তবে ওয়েদারটা এখনো ঠিকই আছে মোটামুটি।
ঠিক আছে, আমরা এবারে এন্ড করে দিলাম। রেকর্ডিংটাও এন্ড করি, কারণ এটা আবার ইউটিউবে যাবে।
হ্যাঁ হ্যাঁ হ্যাঁ।
ওকে, থ্যাংক ইউ এভরিবডি। তাহলে আমি বেরিয়ে গেলাম।
হ্যাঁ আমিও লিভ করছি।